Welcome back. We will now go forward in Intercepts 1 and 2 of the sequential intercept model. Our hypothetical individual, Mr. Smith, has been out and about in the community, but has run into some trouble. We will now explore police interactions with Mr. Smith, his first court interactions, community services available, state-supported living center services available, and possible diversions for Mr. Smith. Let's first discuss police interactions with individuals with intellectual and developmental disabilities. Dr. Price, the police are called out to an incident at a group home. What might that first interaction between a police officer and a suspect look like?
Well, for the officer, if Mr. Smith is in the group home, the plus is there's going to be staff there that know Mr. Smith, can have some historical information, can provide what happened today in case Mr. Smith is not able to provide a good history. So why is today there been a flare-up? Was there a change in routine? Was there an injury? Was there staff turnover? Was there a conflict with someone else? So often staff there can provide some of the background information. When the officers are interacting with Mr. Smith, they may be looking for, is there reason to believe he's suffered an injury, or is there a substance issue? If this was is there a mental health comorbidity that might have been the reason they got called out? Is he suicidal? Does he appear quite depressed? So for the officers, the individual being in the group home also means that if he doesn't meet the criteria for either an arrest or emergency detention, at least he's in a safe environment. Now, the downside of being in a group home, what triggered the police getting called may have been a conflict with another resident or with staff, but this would be very different than if Mr. Smith was, say, in the community. The degree of disability is going to also impact what the officers can do in the environment. If Mr. Smith can provide a history and explain his situation, then they can more easily get his story. What I advise the officers is to slow down, though. Give the individual time to respond and be looking for any indications that there may be some other problems going on.
Great, thank you. A little follow-up to that. If the police were called out to a scene in the community, what other sources of information would you advise officers to go to in order to determine if an individual might have an intellectual or developmental disability, mental illness, et cetera?
Let's say Mr. Smith, the police get called, he's in the community. When the officers make contact, it's either they've been called because, let's say, a minor crime like trespassing, or someone's worried about him. Can Mr. Smith provide you information on who he is? Does he have an ID or not? The officers also may be thinking, if he appears to them to be impaired, is he on an intoxicant? Is there evidence he smells like alcohol? Is there evidence of drug paraphernalia? Right now, unfortunately, meth is very popular on the streets, so that would produce someone who's very different than we'd likely see with someone with intellectual disability that would be more agitated and paranoid. Again, if there's no evidence for or belief that Mr. Smith has a intoxicant problem is the issue. Has he been injured? Is there bruises, bleeding? Has there been a fall, a car wreck, an assault? Is there severe mental illness would be the next thing they're likely thinking. Is he psychotic, hallucinating, delusional thinking, tangential speech? If the officers can get Mr. Smith's name and date of birth, then they can run a background check and see if there have been previous police contacts and what for. If Mr. Smith is unable, let's say, to provide information on where his home is or where he's going, then the officers have to start being concerned about what's going to happen to this poor guy. He may not, let's say, he does meet, just being intellectually disabled does not meet the criteria for emergency detention, so that may not be a good option. If he hasn't committed a crime that requires them to take him to jail, is he going to be okay on the streets? Is he a victim waiting to happen? And what they may be able to do then, if he can give them if the officer knows the district, this is where the officer normally works, they may know that there's a group home several blocks away, or because they've been called there before, they can have communications reach out to the group home. If Mr. Smith can't give you a point of contact, a family member, a caseworker, where he lives, now there in larger departments, there may be a mental health unit that the officer can contact, and they may have resources in the community that might provide temporary respite, say overnight for Mr. Smith. Any other follow-up you'd like me to expand on?
Thank you.
Let's say Mr. Smith was able to give the name of a person, a caseworker, a family member, something like that. Then the officer could have communications reach out to that individual and perhaps come and pick up Mr. Smith or tell the officer where he might be able to go. Worst case scenario, have I seen officers stretch the EDs to say, well, he's dangerous to himself, I'm going to take him to hospitals, I don't want to leave him out here on his own? I've seen that as it's not exactly fit the letter of the law, but it may be the humane thing to do. 20, 30 years ago, they might have taken them over to jail just to get them off the street. We're seeing a lot less of that now with more education on crisis intervention training and what options in the community.
Great. Thank you so much. Melissa, we're going to switch over to you. And as Joe's mom, let's talk a little bit about, there was an incident with Joe and the police. Can you tell us a little bit about what happened in that experience?
So in the incident that is going to play out in the rest of these panels, there was a problem with Joe and another resident of the group home, and the police were called out. And when the officers approached, Joe was frightened and really stressed and was having a meltdown, and he was screaming and, flailing his arms. And when an officer touched him on the shoulder to try to speak to him, try to calm him down, then Joe got really upset and he hit the officer. And this resulted in him being arrested and charged with assault on a peace officer, which is a 3rd-degree felony. Okay, thank you. And we'll have you switch now hats just a little bit. And as an attorney, can you explain if the level of the charge, misdemeanor versus a felony, makes any difference in terms of the possible outcomes for Joe? Yes, it makes a huge difference. As far as the first thing is that misdemeanor assault is the maximum sentence is 1 year in jail. But with this 3rd-degree felony, the minimum is 2 years in prison and the maximum is 10 years in prison. So you are moving up to a whole nother level. In a felony case, there's more likelihood for someone like Joe to remain in jail for a lot longer because the case has to be indicted by a grand jury, which doesn't happen very quickly. It's also just the charge and it being a felony is thought of as a lot more serious, and felonies are not as easily dismissed or diverted as misdemeanors. Sometimes in specialty courts, cases that involve violence are not accepted into those courts. So even though the injury may have been minor to the officer, maybe he had a red mark, it's still a felony. And so it's has major consequences for Joe. This is the situation in which Joe would more likely end up getting a competency evaluation and possibly being put on a wait list to go to restoration, wherever the authorities decide that he should be. So it's a much bigger deal that it's a felony, even though the injury may have been the same as a misdemeanor. The fact that it was on a public servant raised the level.
to a felony.
Thank you. Dr. Price, I want to come back to you for just a minute and ask if you have any other best practices for police interactions or good training for law enforcement officers who would like more information.
Certainly. I'm going to argue that crisis intervention training may well be an unintended consequence of the deinstitutionalization programs we saw in the 70s and 80s. Now we have more seriously mentally ill individuals out of the hospital settings, but the outpatient services available are rather limited. And so they often are falling apart, ending up on the streets, off their meds, and officers are coming in contact with them significantly more often. In San Antonio, for example, 14,000 emergency detentions were done last year. Up until a couple of years ago, an officer was only required to get 24 hours of training in dealing with the mentally ill in their entire career. That's been changed to where they have a 40-hour course as a cadet. There's another 40-hour course to get their intermediate license. If you want to be a mental health officer, there's another 40-hour course. And for basic license officers, there's a requirement for updating every 3 years in this area. We're seeing more efforts to do de-escalation training, cultural sensitivity, stress management, CIT training at the cadet level. But I think a lot of times my cadets see them as lectures or programs they have to participate in the academy. They don't see them as interacting. So it's very important for law enforcement agencies to run real-world scenarios as much as they can with cadets so they understand why these things are all working together all the time. For example, if you have cadets do a call where they have to wrestle someone or break up a fight, immediately get in the car and go to a mental health call and realize that adrenaline and cortisol, the stress hormones that helped you deal with a fight, are now getting in the way of you being calm enough to reason through this and use your training to de-escalate and your emotions are near the surface. Then all the time we spent trying to convince you that you've got to do the breathing between calls. And if you got the death grip on the steering wheel, let go and stretch it out and do some self-talk, because you have to start each call as calm as possible so that the training you've had will kick in and be more useful. For officers, slow down. I know there's a lot of pressure to complete your call and move on to the next call, especially with resources being limited. But allowing someone to talk 5-10 minutes, tell their story, even if you know you're going to have to arrest them, they are much more likely to be cooperative and get in the car because you showed them a little more respect, and you'll avoid the chases and the fights many times, and that is better for the officer and certainly better for the public. The other thing is trying to help officers understand, don't take it personal. No matter if someone's being rude or belligerent, or it's the uniform, it's the office they're mad at, it's their situation they're mad at. Once an officer takes something personal, then it's hard not to allow your emotions rather than your reason interfere with resolving this particular situation. And that's very difficult sometimes, especially when you're just starting out, to not take it to heart the way that you're being treated. That's just part of the work, is learning to take a step back and say, it's not me. I'm going home at the end of the day. I'll never see this person again. They're going to jail or getting the ticket. It's okay.
Great. Thank you. Some really great resources and ideas. We'll move forward. And let's say this officer didn't know that he had other options and decides that Joe Smith should be booked into jail. We're going to talk a little bit about that first interaction in a jail. So we're going to move to Judge Noaker now. Judge, what happens when Joe is booked into the jail?
Well, before we talk about that, what we've just heard from mental health professionals and doctors and people that have been doing this job for years. And I can tell you, to the judges out there, and including me, it's like, what the heck does this have to do with me? How do I apply everything that we've just heard into what we do? And in particular, I'm going to talk about the magistration process. So as the defendant, or as in this case, an inmate, is booked into a jail, the jailers ask him a series of questions. And this happens at every jail, at every booking, at every in-processing. And it's a screening form. And the screening form is intended to identify people who might be in a mental health crisis, who may have been in mental health services in the past. maybe somebody who suffers from intellectual or developmental disabilities, or even if somebody might be suicidal, and if so, what is that risk factor? So there's a series of questions that are asked, and they're yes and no questions, and that form is ultimately transmitted either electronically or a hard piece of paper to that magistrate. And as the magistrate looks over the form, you're trying to essentially, and it's tough to do sometimes when you're looking at a bunch of yeses or nos, or if the jail didn't necessarily collect secondary information in the event that a yes was a response to one of the questions. But the magistrate is charged as to perhaps saying, do I put this person on my mental health IDD radar, much like an air traffic controller and aircraft? So you look over the form, and then at the very bottom of the form is a question that also addresses special education. You know, after the 85th and 86th legislative session, so much was thrust on the shoulders of magistrates when it comes to mental health. All of us are familiar with everything that happened with Sandra Bland. All of a sudden, there was all kinds of acronyms that we're using, or at least that we're forced to be more familiar with. LMHA and LIDAs and 1622 orders and 17032 considerations. All of a sudden, we have to focus a little bit more on terms and conditions of bond. All of that came out of the 85th and 86th. So I really don't have to go into a lot of detail on those processes. But what we haven't talked a lot about, Haley, and I'm really excited that we're talking about it this year in 2020, is IDD, intellectual and developmental disabilities.
Yes, agreed. So next, I'd like to talk a little bit about the CCQ. And so can you talk to us about that process? And do you or your jail staff get any IDD indicators for Joe through the TLET system?
Sure, and it was brought up, I believe, earlier by Dr. Quintero Kong. She mentioned that just this past August, if somebody has been identified as being IDD or received services for IDC, that is now included in the TLET system, and we're certainly in the infancy stages of this. But this is going to be very helpful because, again, out of the 85th and 86th, most judges, at least at the beginning stages, are familiar during the magistration process of looking over that CCQ. We're looking for information that we can pull from it that's going to help us. Again, do we put this defendant on our mental health radar? Do we perhaps want to reach out and communicate with our LMHA? Or in this case, if it's IDD, are we going to reach out to the LIDA and see if there's anything further that we can do or specialize in or be hyper aware of? Which then is going to take us right into the magistration process, Haley. And for the most part, when it comes to mental health and when it comes to IDD, a magistrate judge is going to do what a magistrate judge does, right? For the sake of impartiality and fairness, we as judges often try to do the exact same thing every time with every defendant. So in the event that maybe eyeballs are looking at us, we're not going to hear that question, why did you do this differently? Or why did you do this advisement a little bit differently? And that's what judges want to gravitate to. It's a security blanket for us, right? I mean, I do it the same way. Law enforcement say it all the time. Based on my training, knowledge, and experience, this is why I did it. Well, judges sometimes fall into that themselves, and understandably so. But what this is forcing us to do as judges is now we have to look at somebody perhaps a little bit differently. In other words, if we have somebody who, and I'm sure many of us out there that are judges have seen this, and I've certainly seen it several times, but you're dealing with a defendant who's been arrested. We see that they may have been in some type of special education classes. Let's say we got some hit on a CCQ notice through TLETs. Let's say we have that information. Well, do we really want to communicate with them the exact same way that we communicate with everybody else? We just heard from professionals across the board on certain things that you want to look out for. And we've heard it in clinical terms. And as judges, we are forced now to take the clinical terms and how do we apply that to what we do? Well, I find that there are certain tricks that I'll try to apply during magistration in the event that I have somebody that might be intellectually or developmentally have a disability in that respect. Sometimes, maybe the way that I do my 1517 advisement, I might word it a little differently. I'll do the 1517 advisement normally, but I am prepared to try to explain it further in the event that they don't understand some of the things that I've said. You know, there are times that defendants just want to be difficult, and they might push you or challenge you during a 1517 advisement. And the challenge to the judge is, you know, wait a minute, let's not get frustrated with this process. Let's treat this defendant uniquely. Dr. Price said it earlier. Don't take this personally. Perhaps there's an underlying reason that this defendant is asking the questions that they're asking, especially if this defendant was on your MHMR radar. So as we, as judges, process this defendant, as we communicate with the defendant, maybe we can minimize some of the flashy things that are going on around us. For example, if you look at my office, I got an airplane there and I got an airplane there and flags back there. These are things that if in person or even perhaps by video, somebody might focus on those and not even listen to a word that you're saying. They may want to talk to you about some of the things that are there and not really want to talk to you about what the process that you're doing as far as it relates to magistration. So perhaps we can kind of simplify the environment, make it a little bit easier, perhaps minimize distractions that are going on around us. Generally with a person that is not on my mental health radar, I can handle magistration. There can still be some activity going on around me. Jailers walking by, perhaps another defendant in the booking department sitting on a bench. But in these cases, I try to, again, simplify the environment, remove some of these distractions from the process, and I find that it's very helpful in when I deal with this defendant. So as I'm dealing with the defendant, there's a few things that I want to do. If this is a person that we have potentially identified or even confirmed as being IDD, we're going to want to reach out to our LIDA. And we've heard this acronym mentioned several times. I can tell you that in Burnett County, I think we have absolutely the best local mental health authority in the state of Texas. It's Bluebonnet Trails, and they're very responsive to me. And when I talk to Bluebonnet Trails, if I have a question, I always get the answers that I'm looking for. If I have a problem with something, most often they're working on trying to find a solution to the problem. Well, another great thing is that our LIDA is compartmentalized within our LMHA. So that makes things really simple to me. So as I reach out to Bluebonnet Trails, it really is kind of an all-encompassing outreach on my behalf. But we want to communicate with the LIDA and see what insight do they have historically, and perhaps are they going to give us some recommendations for this defendant in the event that there might be a 17032 consideration. And in that case, that would be a mandatory personal bond. And there are certain exceptions to that, but it does say shall. If we look at the statute, it says shall when it comes to 17032. It's very difficult sometimes for judges to want to order, but the statute tells you to do it. So darn it, you better do it. But if you're going to do it, then get hot and heavy on terms and conditions of bond. Nothing unreasonable, but things that make sense, things that are going to help the adjudication process. And then let's throw in some things that are going to be beneficial and helpful to that defendant as well. And you can get recommendations and suggestions from that LIDA, or if you've done this several times, there might be certain resources that have already been identified by you.
Thank you. So much good information. Next, let's talk a little bit about the appointment of an attorney. So at what point would you appoint Mr. Smith an attorney throughout this process?
And it's not really fair to present that question to me because in Burnett County, we have a system that is set up so perfectly for this, but I know a lot of other jurisdictions out there don't. Somebody at one time had the genius idea in Burnett County to not only say we need a full-time magistrate, but we're going to make that magistrate the mental health liaison, and then we're going to give them indigent defense appointing authority. So when I have a magistration hearing, I immediately transition to indigent defense, and I'll make an appointment if the person qualifies for a court-appointed attorney. I can tell you that when I have somebody that is on my mental health radar, if I've met with them during magistration, I always encourage people to try to meet with the defendant before magistration to give you more insight as you roll into this hearing. But if I meet with somebody and I feel like, you know what, I did a 1622, or I've had to reach out to the LMHA, I had to reach out to the LIDA, In my mind, I am going to go ahead and default an appointment for counsel. And Burnett County, we have a public defender's office who is phenomenal when it comes to defendants who are in a mental health crisis or may have special needs as it relates to ID. And we will always default to them. Sometimes they might be capped out on cases, or sometimes there might be, they're conflicted out for whatever reason. Then we have a handful of attorneys on the wheel that I know that I can trust and rely upon when it comes to providing those special and unique services that an attorney needs to provide to somebody. We heard earlier from Melissa Shear, and Melissa can speak probably volumes to the fact that when you're dealing with somebody who is in a mental health crisis or has been in mental health services, somebody who is IDD, it's a very different way of representing that defendant and advocating for that defendant moving forward.
Thank you so much. Speaking of Ms. Shearer, we'll flip back over to her and talk about, speaking as a family member, we've heard some really great information from the judge. What changes could lawyers, judges, or mental health professionals make to best serve Joe or other people with intellectual or developmental disabilities?
I think one of the really big things is that as lawyers, we frequently will. There's a lot of talk about you can only talk to the client, you can't talk to anyone else. Get permission from the client if there's someone that is a support person that they would like you to talk to. Because a lot of times they have a parent, a guardian, a caretaker, a friend, or someone that is helping them get along in the world. And when you're at court, there's like a long list of things that you're asked to do. And under that much stress and with an intellectual or developmental disability, it's very likely that the person is not going to remember the laundry list of 10 things that you told them to do before they come back to court. So having another person that you can be sure is still supporting that person and knows what the plan is also is really important. And so please ask the client for consent to talk to someone. And then when you do that, you can limit it. You can say, can I talk to your mom about getting you home? We don't need to talk about the facts of the case, but can we talk about getting you home? And so that's really important. Another thing is that with personal bond, or say you get an ID bond, or if there's mental health also and you get a mental health bond, be sure that there's someone to pick up this person when they walk out of the jail. I know a lot of times there are things written down on the bond that say you're supposed to go to this appointment tomorrow, you're supposed to go to this appointment the next day, but there's not coordination with what's going to happen, like how are you going to get there? And so be sure that there's someone that's picking them up and that they're not just walking out of the jail by themselves at 10 o'clock at night and not knowing how to get home. I've seen that happen, and that's devastating. Another big, very important thing is to identify yourself to the individual multiple times, and also identify yourself and explain who the other people are that are around. Be sure to explain who you go to for what. And ask open-ended questions. When you're talking with someone with an intellectual or developmental disability, a lot of times they will give you the answer that they think that you want to hear. Like, do you understand what you're supposed to do when you get out of jail? Yes. But you really need to ask, tell me the things that you're supposed to do when you get out of jail. And, write them down, give them that information a few different ways. And also give them reminders.
Thank you. Judge Noaker, I'm going to come back to you and just, do you have any final advice for judges or jail personnel on how to proceed when they find themselves thinking that a person might have an intellectual developmental disability?
I do. And I'm going to use my backdrop right now as an example. Judges, we like to have a presence when we are addressing a defendant. When we're in a courtroom, that courtroom is our courtroom, and darn it, we have control of that courtroom. And things are going to happen the way that we want them to happen, and we're going to order it. And if you don't comply, there may very well be a consequence. But I want to tell you that when you're dealing with somebody who may be in a mental health crisis, or somebody who's been in mental health services, if somebody who is ID, and through all of the information that we have rummaged through, as far as the CCQ notices, as far as the questionnaire, as far as our conversations with the defendant, perhaps there were some other resources that were tapped into. It is important, judges, that we take a deep breath and maybe forget about some of the presence that we have. You may be able to tell that I'm kind of a type A personality. And when there are certain times that I even recognize, and this is tough for me to say, but I even recognize, Kirk, you better tone it down a little bit. Or Kirk, I talk a certain way, maybe I can find a different way to communicate with this defendant. Maybe I should smile a little bit more. Maybe I can communicate with the defendant while still knocking out every statutory requirement of magistration, but maybe I can come across much like a friend or a family member would communicate with that defendant. As long as we're meeting all of those judicial check marks that we have to do in the process of what we're doing, but yet we still are mindful that we are effectively communicating with this defendant and not only doing everything that we need to do according to statute, but doing things that may very well bring services and benefit to that defendant. Everybody wins. The defendant wins. The criminal justice system wins. The judicial process wins. Everybody wins. And that might just start from people like me who believe that presence is everything, image is everything. Maybe sometimes we need to tone it down a little bit when we have a defendant in front of us that would be more responsive to that toning down.
Thank you so much. Let's move a little bit over to discussion about diversion and bonding out, and talk a little bit about community services again in relation to where we are with Joe in the Intercept model. So Dr. Quintero-Conk, I'm going to come back to you and ask if you could give us a little bit of information on what diversion options exist for Joe through the LITA.
Well, the role of the LITA is to look at what are the least restrictive environments that the person may be able to qualify for. Some of this may be just in-home services, and an assessment would be done to see if the person qualifies for that. The person may need, and often it is the case that they need out-of-home placement. Some of the group homes, the 6-bed group homes that are in communities, may be an option. The LITA can help facilitate placement and a search within the community and sometimes even across the state. One thing to consider, though, those are homes that are run by private companies, and there is a barrier at times, depending on what the offense is. The company may say, no, we don't take people that do whatever Joe in this case might be accused of doing. There is also the possibility of a home and community services diversion slot. This is something that the crisis intervention specialist can help navigate, which is a special Medicaid benefit package for individuals who qualify for those services. All in all, it's up to the LITA to work with the individual, the family, to be able to present the kinds of services for which the individual might be eligible for that could be part of the bond package that's presented. I want to do one request, knowing that we have a lot of attorneys, judges, others that are in a position to help. There is one barrier that the LITAs frequently encounter, and that is gathering information on the person from previous assessments, particularly before age 18. So if we know that we're dealing with someone who has IDD, if the attorney can immediately start gathering that information, anyone can marshal those resources, that really does move the process a lot faster.
Great. And Claire, I'm going to come back to you and see if you have any more context or ideas for us about diversion opportunities that might be coordinated between the LIDA and the State Supported Living Center.
Sure. Yeah, I just want to reiterate the idea of looking at diversion. So when someone applies to an SSLC, the LIDA works with the person and the individual support system to access any diversion, exhaust all community resources. The SSLC should really be the last option. All other sources have been exhausted, and that kind of comes in with the commitment to the SSLC. When we receive a packet, we also look at that and we continue to work with our LIDA partners. We'll review the packet. We'll look for opportunities for diversion. We've had several projects as of late and partnerships with the LIDA to discuss what those different options are, to educate folks on both ends, the LIDAs and the SSLCs, on what those options could be, so that we're advocating on both ends. We're really making sure the folks that come to the SSLCs are the folks that really need us, and other options have been exhausted. And if there is a diversion route, there's a rationale on why that's been tried and is no longer an option, or why it's not going to be tried. So we really do look for opportunities to advocate for that person, making sure that they've explored all diversion avenues before coming to an SSLC.
Great. And Melissa, I'm going to come back to you. And if the least option, as Claire's just described, is not tried first, do you have any thoughts on how that might affect Joe, either short-term or long-term?
Right. I feel like we need to try the least restrictive options because for a number of reasons. One, we want to keep someone in their community with their family, their supports, rather than moving them somewhere far away to be in an institution where they don't know anyone. No one knows them. And there's more limits on what they can do. Whereas a lot of times in the local community, there are some innovative programs that are out there that a person could participate in. The other issue is that the less opportunity you give a person with an intellectual or developmental disability to thrive in the community, and try to learn how to live in the community, but instead you put them in an institution, you're limiting their potential and their future abilities. And I would just really reiterate, whenever someone is on a waiting list for a state-supported living center because they're wanting because someone wants competency restoration for them, they can be waiting in the jail for years before they get there. And that is a trauma that they will never be the same.
Thank you so much for that perspective. I appreciate that. We're seeing some real themes, and I think we're all breaking down silos as we work through this panel. So we're at the very end of this panel. So just to make sure that I know several people have discussed it throughout the presentations today, but just remembering that we do have, diversion opportunities. Dr. Quintero-Conk just talked about it, talked about how we have a process by which you can get people quicker access to Medicaid waiver services without having to, wait the years on the interest list. And by contacting your LIDA, they can get you access to an application for those expedited slot requests. So I want to just double check with Claire and Dr. Quintero-Conk, anything else you guys want to add? I know you guys covered it pretty well, but we just had a couple of extra minutes. So I wanted to circle back and make sure you guys shared everything you planned on sharing.
I'm pretty good. Is there
all right
out there?
The only thing that I would mention, just to kind of piggyback onto some of the things that we had discussed, was the other reason why diversion is so important is to make sure people in a less restrictive setting, make sure that they're in their communities and they stay connected to their families. But another reason, just an operational impact, is, the longer, the more folks that are kind of trying to come into the one door. So in this example, in SSLC, if we're not exploring opportunities to divert folks and we're not exploring different options, the lists for folks to receive those services like SSLCs, state hospitals, or what have you, will get longer. So that's why we really need to, and we've discussed this in a lot of different panels, identify who needs services early, identify who those networks are, and really getting people what they need as soon as possible, so that if they are standing in line or waiting for some service, they're in the right line, and the few amount of people in that line, they've been diverted elsewhere so that we can perform that service as soon as possible for the folks that really do need some of those more restrictive settings.
Thank you.
And, actually, I just want to add one more thought. Our IDD community system has not traditionally had to deal with people who are in regular contact with the justice system. It's not that it's brand new, because certainly we have had that, but we really need to look hard at what resources we need to have in order to be able to address the needs of this population, with integration and community, with the old concept of normalization, with being in least restrictive environment. We're tasked with recognizing that people will have contact with the law, and we need to expand our services in a way that addresses those needs effectively.